court Supreme Court wɔn de wɔn nsɛm ato adwa enti sɛ de bia yɛ no mpanimfo agina simpie so wɔn de nsɛm to dwa enti yɛnkɔ tie lawyer Amaleba wɔn nsɛm a wɔn ka wɔ atemuo no akyi. Abusiafo said yesi banana ye share ensem no said yesi ekoye e bia na brofo no aye bebre aye gidigidi ewo wasomu a enu nti e na ye nsentwerefo titiriu said ya na nkrofo e ka no ye ne aye ka akankasa no ye kirekire mu said ye be omamfo ebetimi ate ase ewom se ensem a mpanimfo de tu edwa no e wapa e tententen e court nsem e na wo mu e de atu edwa na said ye sia ye ne wo se ye bo no tofa se ebre ko se ya no ye behwe na ye kikhem ye bubu no tot ne ya kirekire mu nkakra nyame ya adom a ye nim se ye befre a lawyer for titiriu ene lawyer twiremu akodua obeba na oba betena se na yakase judgment no odi ni nyina ba betudwa na wakiremu yie na no so entiase na timi aye adwuma ebi wo ho na wo hwe ne wanka ne yie ana akwakoye asem e de ama ho ene enim so se atemu adwuma no e baaye e be kan ye se abra wo mu ebu asem yi yensem e be kan no yenhwe se de wo mu kan ye no pepepe e na yenfa emetudwa eni kwan se ye de bi kan ho ana ye yi bi firi mu enu ti sa pepepe ne ye be ye no na ene abra empanimfo e hye ye se maachi da a eno etoso nan ena wo behwe wabua asem a enka ne mampanyi John Dramani Mahama e de koto wonum anim se afimpinu ni aduonu aba ye kokoto ye no enya de a de ba ye no outcome no enya de a wo mu ehu ni se fata se bema mampanyi Akufo Addo atena so se mampanyi ni nyina ne se wo mu bu enkonta no a wo mu hu se emma se wonya na ye ka se wo ye mampanyi sa 50+1 a se eno no emma ni dimu se mampanyi no wanya eno ntinka Supreme Court onhwe na wonhye abato commission edikan Supreme Court montungu na wonhye abato commission ma wonsan yento aba foforo na eno na eneyi a ye kasa de Supreme Court o kire se wo mo nsem na wo de betu edwa no enya de a wo mo ewo nyina so obi a betimi ama ho kwan ama de wo mo ehwehwe free court ho no aba enu nti nsem no wa dismiss kire se wabo atuagu na sei na wotemuani panyini a wono ewo Supreme Court ye justice enim yeboa ensema hodo ni bi a wode atu edwa enie abra Supreme Court hwe no wo kire se maami Jane Mensa se ye kapa afimpinu ne aduonu se de wosi eye na adwuma ene se de wo mo so ede beto Supreme Court no anim no adansefo a wode ebaaye no eno eye fa baabi no adansefo a wode ebaaye no na eni kwan se wo mo strong room ho no na eni kwan se wo mo free ho wo mo adwuma a na wo mo ye no strong room ho no na wo mo nyanwie ye enti na bibie ni ho a esese eto wo mo ma wo mo free sa strong room ho efiri ho kra abra wo mo adwuma mo ye no wo mo nyanwie ye enti se wo strong room ne ese hwe ho na obi aba be ka kire se pie free ho no wa pie free ho abra wonim se wadwuma wo ye no wonwie ye a eno no na enye wo mo na ye de sobo no ebebo wo no afei eno akiri no nanka ewo se anka party ahodo no nanka wo mo strong room ho no mpo no ko betimi afra afoforo ni bi esan se na wo mo a wo mo ya dansefo no mo strong room ho no mpo no wo mo ni wo no bibisi ho a ko betimi afra wo mo nanka ebia wo matimi aba be yi ano nti nsem na ahodo no edo so pa a ogina so ede ba nti yenko na yentie se de nsem no esi etie yenko tie ana yenko Supreme Court yentie se de nsem no ento aso no esi etie
The election was conducted so badly that it was not substantially in accordance with the law. As to elections, the election is vitiated irrespective of whether the result was affected or not. 2. If the election was so conducted that it was substantially in accordance with the law as to elections, it is not vitiated by a breach of the rules or a mistake at the polls, provided that it did not affect the result of the election. 3. But even though the election was conducted substantially in accordance with the law as to elections, nevertheless, if there was a breach of the rules or a mistake at the polls and it did affect the results, then the election is vitiated. When Lord Dennis' propositions are read as a whole, the combined effect of the propositions is that an election will be voided upon the occurrence of infractions that actually affect the votes of the citizens cast at the polling stations, and not the incidents of administrative errors and or mistakes committed by officers charged with the conduct of such elections. We find this same sentiment expressed by our own eminent jurist, Adinina JSC, in the first presidential election petition case, Akosua and others versus Mahama and others. Number 4, 2013 Supreme Court of Ghana Law Report, special edition, page 733 at page 237. 237 to 238 per her ladyship had this to say, quote, courts usually apply the election code to protect, not to defeat the right to vote. Public policy favors salvaging the election and giving effect to the voters' intent, if possible. The right to vote is at the core of our democratic dispensation, a principle I've affirmed in this opinion with reference to the Tenadi and Ahuma Okansi line of cases. End of quote. Conclusion. We conclude this judgment by emphasizing that the petitioner did not demonstrate in any way how the alleged errors and unilateral corrections made by the first respondent affected the validity of the declaration made by the chairperson of the first respondent on the 9th December 2020, as already stated in this judgment. The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason to order a rerun as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit.
As the court pleases.
Abusia kwa ba ni say de na lawyer for na say ye de asema beto omo so. Wo mo no e na be kirikire mu amaye. Yenko lawyer John Darko on de finra ya twe na bo so saa ye bisa no sesen e na osi ehu ye. Lawyer John Darko ye senior lecturer e wo Gempa Law Faculty ye no eni enkomo lawyer wadaro Martin nka ma he yo lawyer wadaro ma wo eje bo eja wanya ba bedru ensamo ekosi wadaro ma ubetimi a kire emu kakra sa atemo yi abai ase ene sei
yo minyan ba mi dase na me chia paki for the phone.
Okay,
so you can remember nyame adom jebo ejanya bedru ama ye hunu de ekusi o what need to find the big time how to be a share and they say a year petition you are doing hammer or the Ecuador Supreme Court no abogu court no asema or the eba court no in subi any ho asema no person court no na dey person court no eyema no court no ensan electoral commission so the be electoral commission every time aye relevant and I say obesa me ato abani bi eye one na adro president na if you say umu bia enya more than 50%. Na Korea say court no accept ama yehunu say hwema anokwa na do nya more than 50%. I mean say ye de yurajo mama penoa eleyi yiti ewi no any court proceedings ni na dey back yehunu ye and say yura esedu enketia onu na ni tu ojetu mu say about na etu no president na do we are more than 50%. In fact, we are 51.259 of the valid vote cast. Now, I don't know, I say, about 20 now, about 20 now, and I can. The valid vote cast, not the vote cast. Now, was from the Supreme Court explanation with the mind, not to say, valid vote now, it was an NDC for another Ramama, which is not so any calculated percentage, or maybe we sue all the vote cast. I know that a year error, and I say mistake, and not my man, Jemensa, who declare results no kind. In the same Quebec, the valid vote cast, no kind, the valid or kind of vote cast.
Okay.
And it is the difference, but throughout the proceedings, throughout the question, the court examination, it became clear that Nanado with a 51.259, and then the Supreme Court every trigger, Omode to throw the Chima South, Vienna, and my own. I fear a buy and Omode to throw, Omode to throw, who said, a consider a Janissa Bois, Nana Ado, now we have more than 50%. I mean, see a woman main issue, and now also court may decide, say, electoral commission, the declaration. Now, it's young Article 63 of the Constitution. Now, a bad side, Article 63 of the Constitution, as they say, and sign the answer to be a winning presidential election. No, also we have more than 50%. Now, you are receiving Katia and your mama. How much I said, about a 3 and now we have more than 50%, and it's now, they declare that this way, we now that declaration was a violation of Article 63 of the 1992 Constitution. But clearly, from the judgment, and from even the evidence before the judgment, even I said, a Beer Electoral Commission or Cast and another, were really abandoned. Now, the Constitution, you are more than 50%. Then you
liar.
Okay,
liar, Wadaroma. My Simaka Krebi, ye pesa utie, ye Cananado Danko Kufuado, na lawyer for Woma business in Piso, almost so ede, Womo Bono Tofa, dear Womo Jennifer at him whereby no. Wadam pesa utie Kakrebi, my area, no more comment to home.
Sure.
Okay. Yeah. Ebusia yenko tie said a lawyer former MPP and na Nanado Danko Kufuado, ye tie woman nsem wo de to dwa no. Ye
A very good afternoon, ladies and gentlemen of the press, and a good afternoon to our fellow countrymen and women. After 3 months of trial in the highest court of this land, others refer to it as the apex court, the Supreme Court has today finally handed down the verdict of the court insofar as the 2013 election petition, 2020 election petition is concerned. It was a unanimous decision of all the 9 justices, 7 justices of the Supreme Court. I want to highlight a few of the things that the justices said for purposes of emphasis and general understanding. It was a 2-hour-long rendition, so I cannot do all, so I'll just highlight the salient points for brevity. Your Lordships started the delivery. Of course, the judgment of the court was read by none other than the Chief Justice of the Republic, Justice Kwesi Enin Yeboah. They drew a distinction between the election petition of 2013 and that of 2020. Whilst the election petition of 2013 mounted a challenge to the validity of the election and called for the annulment of over 4 million votes due to overvoting, irregularities, lack of biometric verification, and absence of signature of presiding officers. The 2020 election petition was basically a challenge against the declaration of the results and not, emphasis, not the validity of the election. It was the declaration of the results that the petitioner sought to challenge. But the courts held that the declaration of the results is done in consonance with the data provided by first respondent. That is the total number of votes cast, the total number of valid votes cast, and the percentage of the total number of valid votes cast, and not the total number of votes cast. I want to stress the difference. It's a percentage of the total number of valid votes cast, and not the total number of votes cast. And by the data provided, the justices were left in no dispute that second respondent, His Excellency Nana Addo Dankwa Akosua, President of the Republic of Ghana, and still the Commander-in-Chief of the Ghana Armed Forces, had crossed the threshold of more than 50% plus of the total number of valid votes cast. In consonance or in tandem with Article 63(3) of the Constitution 1992. The court had a word or two to say about the testimony of the witnesses for the petitioner. And you heard the court rightly say that the petitioner was under no obligation to offer evidence himself by the presentation of a witness statement and mounting the witness box to testify. So was it that there was no compelling reason why first respondent and second respondent should have been made by all means to also adduce evidence in the trial. So there is parity of justice. Your Lordship said that the evidence of PW1, PW2, and PW3, that is Dr. Michael Pesa-White, and Mr. Johnson Asiedunkit, and Mr. Robert Joseph Metanunu. And I'll borrow the language of the court. It's not my language. The justices said their evidence was fanciful, and the least said about the evidence of these two persons, the better. That is not my language. That is the language of the Chief Justice of the Republic and of the court. Why did they say so? From the evidence adduced at the trial, their own evidence, they have certified 13 of the 16 regional collation results, and when they realized that the other 3 results were not favorable to their cause, they abandoned ship and left the National Collation Room of First Respondent, what hitherto was called the Strong Room. Your Lordship said they abdicated their duty and their evidence that they were tricked by First Respondent's chairperson to vacate the room before the declaration of results was unworthy of consideration, and that they should blame themselves for abandoning posts and not shift blame onto the doorstep of the first respondent's chairperson. This is the language of the court. In fact, the court also said that they had 2 additional agents, so that even if they left, the 2 of them left, the 2 additional agents could have done what they should have done as agents in the collation room. PW2 and PW3 were under no obligation to leave the room, and the fact that they decided to leave they cannot complain of the declaration made in the error. Now, when it came to the star witness, Johnson Asiedu Nketia, this is what the court said. We did not come to court to challenge the figures declared by first respondent, but that the figures declared contain errors, and in affecting the errors, the EC chairperson unilaterally declared the results contrary to Article 23 and 296 of the Constitution 1992. The Lordships posed a rhetorical question that what was the effect of this? And the answer was forthright. Your Lordship said the petitioner did not present any compelling evidence that there were breaches of discretion of Articles 23 and 296 of the Constitution 1992, and that errors by administrative tribunals are not matters for determination by the Supreme Court. That challenge lies squarely with the High Court. And that the discretionary power, if not exercised according to law, does not invalidate the valid votes cast at the election, and that those errors cannot amount to an invocation of the original jurisdiction of the Supreme Court. I will shortly, in the course of my delivery, tell you some significant portions of the evidence which were quoted extensively by the justices to found the reasons for the judgment. Now, there were 5 issues that were settled between the parties for the consideration of the court. The first one was whether or not the petition disclosed any reasonable cause of action, and the others followed. It's whether or not the petitioner, the second respondent, obtained more than 50% plus of the total number of valid votes cast at the election, and whether or not the alleged vote padding and errors substantially affected or materially affected the outcome of the election. There were other ancillary reliefs of a breach of Article 23 and 296 of the Constitution 1992, a mandatory injunction placed on the EC, and also an injunction to restrain the President from holding himself out as President of the Republic, and for that matter, carrying out his duties as the first gentleman of the land. It is instructive to state that the courts decisively determined these issues in favor of the respondents. Indeed, to do fidelity to the Supreme Court and the truth. We cannot run away from the fact that the Supreme Court did not agree with the first and second respondents on the first issue, that the petition did not disclose any reasonable course of action. But they were quick to also say that the petition will not be determined alone on that issue, and that the totality of the evidence will be called into play to ascertain whether or not the plaints by the petitioner, that none of them, that is the petitioner and second respondent, crossed more than the 50% threshold as mandated by Article 63(3) of the 1992 Constitution. Now, this is what the justices of the Supreme Court said to clarify and put to rest this thorny issue. Now, the actual total number of valid votes cast at the election, which was admitted in paragraph 12 of the petition and confirmed by the star witness, Asiedun Ketia, was 30,121,111 votes. Now, the court also said that a party is always bound by its pleadings, and the only way the party can free itself from its pleadings is by way of an amendment. The admitted position of the petitioner, which was unraveled under cross-examination by second respondents' counsel, the Venerable Anthony Akoto Ampao. I bet most of you didn't know the first name. As the Venerable Anthony Akoto Ampao. When the video clip was played in court. Now, second respondent garnered 6,730,413 votes. Petitioner garnered 6,214,899 votes. And the percentage of the valid votes, of the votes obtained against the total number of valid votes cast, came to 51.295% for second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, and 47.366% for the petitioner John Dramani Mahama, meaning that second respondent had crossed more than the 50% plus of the total number of valid votes cast at the election, which was in contradistinction to what the petitioner had been saying all along. In the first place, before this petition was filed, the petitioner was bold to say that he had won the election, and the Deputy General Secretary of the NDC gave the petitioner a percentage of 50.15%. You heard it when the video clip was played. Indeed, Sami Jefi, a communication officer of the NDC, hailed John Dramani Mahama as the president-elect. This position taken by the Supreme Court was not done in a vacuum. It was elicited from cross-examination of their star witness, PW1, by the Venerable Akoto Ampao. And you heard the rendition, which was lucidly given by the Supreme Court. Now, the Supreme Court also considered the Techiman South constituency presidential election results, which became a thorny issue in the declaration. It was the first respondent's chairperson alluded to the fact that even if the Techiman South, what's happening? Even if the Techiman South election results, presidential results, were added to the results at the time of the declaration, the second respondent still won the presidential election by more than 50% of the valid votes cast at the election. Now, the declaration of the results was tendered in evidence by the petitioner as Exhibit A. And Exhibit A clearly showed that the votes at the Techiman South constituency, and that without the Techiman South constituency election results, second respondent crossed the threshold and obtained more than 50% plus of the total number of valid votes cast. The addition of the Techiman South constituency results was played out in the manner following. The total number of registered voters in that constituency was 128,018, but 99,436 valid votes were cast at the election. And out of that number, the petitioner, John Dramani Mahama, received 52,034 of the valid votes cast, which put his total number of valid votes cast at 6,266,923 votes, which represented 46.379%. Second respondent, Nana Danko Akosua, received 46,379 votes, moving his total number of valid votes cast to 6,776,792, which gave him a percentage of 51.295%, meaning that second respondent had crossed the threshold of 50% plus one. The Supreme Court justices also held that in fact and indeed the results of the Techiman South constituency presidential election was well known to the petitioner before the petition was filed. And for that matter, even an exclusion or inclusion of the Techiman South presidential results wouldn't have made any difference at all to the results as declared by the EC's chairperson. And now that even if the total valid votes, all the votes are added, Nana Dankwa still received 6,730,413 total number of valid vote cast, and that of a percentage of 30,249,129 votes would have given him 50.798% votes cast. As to the alleged vote pardon and the wrong aggregation of votes, the Supreme Court dismissed those allegations with consummate ease. Indeed, if you added the votes that they themselves said were pardoned, in one instance it's 6,622, another instance is 5,562, and then when it mattered most, they initially started with 32 constituencies and it dwindled. They started with 32 constituencies and it dwindled to 26 constituencies, and the vote pardon came to 4,693. Now the courts were clear that these votes, even if taken out of second respondents' votes garnered, did not materially or substantially affect the validity of the election. The Supreme Court also said that the alleged vote pardon was not supported by any credible evidence, and you can't rely on infractions that affected votes at polling stations when the votes are validly cast. Administrative errors or mistakes by electoral officers can never and will never change the sovereign will of the voters who cast their votes at the election. And your lordships quoted a passage from Lord Denning to support that position of the law. Ladies and gentlemen of the press, in short and in brief, this is the thrust of the judgment of the highest court of our land. And your lordships posited that one cannot ignore the substantive truth of an election and resort to innocuous errors committed by first respondents chairperson in the declaration of the results, and on that position call for a rerun of the election. Your lordships also stated that the petitioner was not able to bring one single piece of evidence to show that the allegation that none of them, that is the petitioner and the second respondent, crossed the 50 plus of the total number of valid vote casts to warrant a rerun of the election. The Lord Justices of the Supreme Court have spoken. We entreat all Ghanaians to abide by the decision of our highest court of the land. We thank our good friends on the other side for their bravery in mounting this petition, albeit we all found that the petition indeed contained nothing but factual errors and inaccuracies. Those were in the words of the court, not mine. Litigation must always come to an end. I want to believe that this is the end of the 2020 election petition. I'm fixated with 2013, so spare me. Ladies and gentlemen of the press, If there are any questions, we are prepared. I'll do them. If they don't, Elvis. If there are any questions, we will take them. The mic back to talk
Abusia na yasan afamo every Supreme Court abra nana adodankwa Akosua na lawyer for edsoso yebu asem ni wie omo nsem omo de atu edwana ye ne lawyer John Dakon enewo ahoma ne so ma yama na gina so a wache lawyer akwa babio we dey facha ye pa wadaroma ye bre ne ko eja Supreme Court of abre na bi eti sese no wo bo no tofa kra mayen no enchiremu de utie ye ni de Supreme Court so kan no wo bo no tofa mayen sen na wo de ebe to o manfo ani
yo me aba so je me kan se DSC no ye we say Ghana for ye lawyer law student and Obia wo Ghana here and say Embra and ye dia ye djuma Supreme Court and ne a court so back and kesia wo kuma no de omo asem abetudwa ye na ye ntum asem pa ye koba ye nyina no and say ye djuma na no pese ye nsan koto abafoforo no court no anyantu the Supreme Court ekaye the another lawyers ekaye nyina wo ubo itisi ani nyina na etsa dia ba kote the court no ekaye say ebra ye Mahama eka say another you know nya more than 50% of the valid vote cast no na nya no kre continue out to the dia anche sa na urima na court no sa dia bi nya ne pa the pese ye hwe badodo a wunya ya enye bana ya to no nemu ya to ya gi atum ndi ni patent ekoto aba that is ni ni frima ye kan no eye motwe
okay
ye pe emu wa hamu tichimu adunum a ebeye aduanan
okay
enkoye adunum ye valid vote cast and ye dey na court no any evidence about you now clearly actually say who check a percentage of the valid vote cast Nanado we na 51.295%.
Enti lawyer wadaroma said you see said the court si kan mu no na che say wasan asisudua ema Nanado enyaye.
Court the electoral commission
the buy okay was asisudua lawyer ne kra mu no
okay kind number no saying ko the valid vote cast, not the vote cast.
Okay.
No, and a bear issue.
And a man issue, no. Okay.
Exactly.
Okay.
That course no
actually
valid vote cast as America. Young could be seen Nanado or you was validly elected.
Okay.
Declaration now electoral commission it was consistent with Article 63 of the Constitution. And means court to intimate declaration
okay. Lawyer, you better say papa any adaje ene maje wo bre ni bebre nti we dey fache ye here ya na ebe yo sa ye da say papa you Abusia lawyer John Dakon or senior lecturer wo Gempa Law Faculty ono na ye ne no edi enkomo no na Abusia ye say omanfo be kaye a afimpinu ni edu miensa Abra 2012 elections no ekopie mu me kira na Dodanko Akosua ekopie mu e Supreme Court say ya se ono so enye aba no entum no ye nyina se ebekaye a na enka ne mampanyi John Dramani Mahama wone na pamfo na omo ewo presidency omo te ho na ho na omo hwe free ye in fact na omo hye ntade fufuo a na omo ani age pa ene yantena se ye ya dwen se ye beko na yeso yakwa se mampanyi se enye ono ne baye ora Peter McMahon wono ene be si anemu ma no ewo court ho eti de na ye hwei eye afimpinu ni edu miensa de no abra ye ma verdict ni wieye no na ene yenso ye de ani kotwa bi si wurewura mu akokohwe se sen na ekoso ewo mampanyi atenaye Ghana mampanyin na nado danko akufo adene na bedi akire Dr. Mahmoud Bawumia wo mo so tena ne office said ye yesi hwani ene wo mo so ehweye emom wo de no mo nhwe fitade wo mo tena ase hwe ni nyina edi efri ho presidency mampanyin office ha nti ye wieye no ena chese aha said ye yesi hono no mampanyin abedi akire chese ne papa medase papa sei na akwa koduru ena wochia na obo nimu ase ena odan ni a se ho ano agya wo mo ye adwuma enti obekọ no office na wakọ akotoa na adwuma so de na omo enso ehwehwe ne se court beba aguo se de na wo ma lawyer fo eka no enti ne de ekoso ewo presidency no eno no sa na ekoso ene enti we eye mampanyin atenaye said the course so was Supreme Court. Now, and then one can mampanyi John Dramani Mahama sans or none a day as some local PM or no. And then there one cassa mu pam pine, eco cotier, said the and seminal ABC aye. Now, Yansha said the video no, a see a coy and some said the sequoia yentie a cassano, and said the na a honor SCI.
So we are supporting getting the proceedings and meeting us as weekends to fast officers who can them to.
I just have one comment. I'm surprised that for the various teams, the frontline staff did not include every woman. Both the petitioner, the first respondent, the second respondent, your frontline legal representation did not include every woman, but there are ladies at the bar. And every effort should be encouraged. Is there any reason somebody like Shulabni Kapremu and former Attorney General should be able to explain why this thing should be encouraged in this day and age?
If your lordship will recall,
Frontline. You are for.
if your lordship will recall, on the first day, we proceeded to announce lawyers for the second respondent. And indeed, we did announce Shilabika Proma. When the court said no, we couldn't have more than 4. Because of the COVID protocol. Right.
Now we can carry on. Man, they were good. Great. Fantastic. Thank
Without merit.
Abusiafo we ene koso ewo presidency mampanyi ene na bedi akire ne na adwumayefo wo ho no mani agina yenim se the atmosphere ne esitie wo ho yankwa ahoma ne so prince ayenkan na bo amane efri mampanyi atena ye owo ahoma ne so yembisa ne se de na ekoso ewo ho anije ana omu hurihuri omo she white ana se de siko prince oteme nkama ha
me abana joso
ede na ekoso ho kire yen twamfonyine ne kire yen
yo sabe do ba jiblia o se na fiti eye da vasi ni be ba ye na president kan wo fiti house ase nkofo starte won ti ba ho na ho ye panyanya kakra so dia ba no ko dia won na wo but na ye da e ye election petition e won sem no e betu da no the president of the republic and about office system if you say o juma dibia ye so ti opposition nkofo fiti 11 na ekusi anyumre no nti oba entem na oba no wan chefu anafna tade na nye fufu bin kanisa she coat black na inside no white shirt fufu sa so na the vice president na won na tade no so e buy no afi mpanyefo bi so ti say the secretary certificate to no o she blue black city kaba the channel. Now, before money years, my African way, African. Who want to fool some of the, you know, and I had a shady coat, not an A to fool. Nothing paying for more one at that director or more on I wish a shit for. After a man so said, it's 10 o'clock. And then social distancing. The president of the Republic and then the vice president and the director of communications deny him. Any employee for me to pay and the president of the public office. Then for Okopa, the fast I see about from now to our now. A 1 month for the apart from the Pamabo Mutin, put the uncle the president of the public office, and then Uncle Obiatino and our ocean. And the president too. On the actual word office. After your year, you're a chief because every year. And what to say, oh, we about more we actually office, not we have an office, they didn't
Prince, I'm worried no more, not almost Tonyoman, no more kind of sack. Because what you may not know, about already a ocean, you must actually have a more almost a woman to me, Yami Boshe, no more than almost not why it's not the amount we not almost okay. In the Jubilee House, the president of the Republic, a Mamma Copo, and which is office. She said, we need to be a officer, own couple. Now, the given so be a dear with your office, Asia. We should be not to be peer. Now, that no channel. Copy protocols in place. Have given you a channel, so young another channel. When you had ya, I saw the phone numbers when I'm copied back enough for any this much activities in our movement. I'm not a car. But the president of the public should be anything. I saw an office, I want to let you now. I can be baby say, I can be baby say, said ya, oh boy, a man, and one boy, a man, yes, and Mampenny Beccasa, a hen or Beccasa free, a Flagstaff house, and I say, Casse, a bankesium, and now Beba party office, and I have for him or Beccasa.
And I mean, that's the president of the public about no Numa, a lawyer for who could a man or court. Omode amane ba bepon say John Mesma so mo kudi no nti omode amane ba bepon e wo Jubilee House ye wo hall bu a send auditorium e ho e no bepon beba no omode amane ba bepon omode amane no boni wi na say nsama the president of the republic e wo e kacha lawyer for no any Ghana for nyina no na eye waka nti no num the president of the republic e be hia na legal team a omo kudi na mo ma na wo Supreme Court na say so ohia wa for some time di tema o ma Ghana for nyina e fa sa asemia Supreme Court obuano no odia to
Yo, Prince, ya beda se, yenim se bibia ni a obema yason ate na yama yahwefo so ate sede esi ekọ. Ebusiafo se mo amunim Supreme Court koye ene wode bibia ba betu edwa. Yehunu sede esi akoso nti nyame adom a no num pepepepepepepe. Mampanyi beba bekasa one na lawyer fo enti eno so sede UTV e wa ha ye bo adwuma e ma omanfo mahunu de ekoso e wo Ghana ni wiase afana nyina no ye de no so e bebre mu na ye gina we so de enne kasebo no e wie de no ye de esi midi e de Akosua Sarpong na matade a ehye media e ye Justy Fashions wono e na wo pamatade fefefe e de e ma memema ne e ma obi akwada wan yo wo ko be pamatade fine pa e de ama memema kaftan pa de ye mema ye wo fia hai hu se obi abegina TV so no hye kaftana obi ti se Romeo say mu amunim se do si bo life ne kaftana hye ne nyina Justy Fashions na wapam e de ahye no fefefefefefe na wo hwehwe no a mepacho owo hacho block factory no woni ne di enhwanimu e na afesu so wo ko eye Jowulu Fidelity Bank no no so woni ne di enhwanimu a owo ho ntade ne de okọ a chapo ubehu dodo na ebusafo nyame adom a ye beto aso ewo dawuro ene anwumre nsia ne fa kasebo makram